In the United States, the judiciary, the court system, is divided into various layers reflecting the federal structure of the country's political system. In this video, we're going to explore the federal court system, seeking to uncover the functions, nature, and role of the judicial branch of the U.S. government. In a democratic political system, the judiciary is a critical component of the government and holds substantial responsibility for interpreting and resolving ambiguities in statutes and legislation, administrative regulations, and to provide clarity and stability to the legal system. Its interpretations help shape understanding and implementation of laws across the country. The judiciary is also tasked with resolving civil and criminal disputes, ensuring that there's a legal and peaceful means for settling disagreements and administering justice. Courts are also crucial in safeguarding civil rights and individual liberties and freedoms, ensuring equal protection under the law, and guarding against discrimination or governmental overreach. As part of the system of checks and balances, the judiciary has the power to check the other branches of government. Through judicial review, it can declare laws passed by Congress or actions taken by the executive as unconstitutional, ensuring that no branch exceeds its authority or infringes on rights. The courts also ensure that everyone, including leaders and public officials, are accountable under the law. This principle is fundamental in a democracy where law is paramount and must be applied fairly and equally to all individuals. And a fair and impartial judiciary helps foster public confidence in the government. Trust in the judicial system is crucial for the legitimacy of a democracy, as citizens must believe in the fairness and effectiveness of the legal system to resolve disputes and maintain public order. The United States operates under a dual court system, which means that it has two separate court systems, the federal judiciary and the state judiciaries. This structure is a result of the federalist system established by the U.S. Constitution, where power is shared between national governments and state governments. Each system has its own sets of courts with distinct jurisdictions and responsibilities, but they interact and overlap in some complex ways. The federal court system is prescribed in Article 3 of the U.S. Constitution and various federal laws. It consists of 3 levels and has jurisdiction over cases involving federal laws, constitutional issues, controversies between states, and cases in which the federal government or foreign governments are parties. The individual state courts are provided for in the individual state constitutions. While they vary somewhat, they generally have 3 levels, echoing the federal system of trial courts, appeals courts, and a Supreme Court. State courts handle the vast majority of legal disputes in the country and have jurisdiction over state law, most criminal matters, family matters, contract law, and personal injury law. The federal and state court systems interact in several ways. The Supremacy Clause found in Article 4 of the Constitution provides that the Constitution is the supreme law of the land. This means that when a state law conflicts with federal law prevails. As a result, federal courts will generally hear cases that originate in state courts if they involve federal questions or have constitutional issues. Some cases may fall under both state and federal jurisdiction, generally referred to as concurrent jurisdiction. In such cases, parties may choose between state and federal courts for where to file their cases. Examples include some types of civil rights cases and crimes that violate both federal and state laws. Typically, cases are appealed through the court system of their origin. However, the U.S. Supreme Court can exercise appellate jurisdiction, permitting it to take cases from state Supreme Courts to the U.S. Supreme Court if there's a federal question involved, such as a question involving the U.S. Constitution, federal laws, or treaties. The federal court system in the United States is structured into 3 main levels, each with its own specific roles and jurisdictions. These are the U.S. District Courts, the U.S. Courts of Appeals, and the Supreme Court of the United States. Most cases enter the federal court system at the district court level. Across the United States, there are 94 judicial districts, including at least 1 district in each state, the District of Columbia and Puerto Rico. Larger and more populous states have more than 1 district. California, for example, has 4 federal districts, 1 each for the Central District centered in Los Angeles, the Eastern District headquartered in Sacramento and covering most of the Central Valley, the Northern District located in San Francisco and extending along most of the Northern California coast, and the Southern District located in San Diego. District courts are the general trial courts of the U.S. federal system, handling both civil and criminal cases and exercising original jurisdiction in cases involving violations of the Constitution or federal laws, so-called diversity cases involving disputes between parties from different states or countries, and an amount in controversy usually exceeding $75,000. Cases involving the United States as a party, or other types of cases or controversies as specified by Congress. The U.S. Courts of Appeals, sometimes also called the Federal Circuit Courts, generally hear appeals from the federal district courts. There are 13 appellate courts that sit just below the U.S. Supreme Court, and they're divided into 12 regional circuits, plus one, the Court of Appeals for the Federal Circuit, that has nationwide jurisdiction over specific issues. Each Court of Appeals normally hears cases from the district courts within its circuit, as well as appeals from decisions of federal administrative agencies. For example, the 9th District Court of Appeals, located in San Francisco, hears appeals from all of the federal district courts in California, as well as Alaska, Arizona, Hawaii, Idaho, Montana, Nevada, Oregon, and Washington. The primary function of appellate courts is to review the decisions of the lower courts, the district courts, administrative agencies, and some federal regulatory commissions to ensure that laws were correctly applied and that procedures were correctly followed. The courts of appeals do not hold trials, but rather exercise appellate jurisdiction, deciding on legal and procedural issues. In doing so, they act as a check on the district courts and ensure the uniform application of federal law across the circuits. Finally, the U.S. Supreme Court is the highest court in the federal judiciary. It's comprised of 9 justices, 1 Chief Justice and 8 Associate Justices, appointed by the President and confirmed by the Senate. The Supreme Court exercises original jurisdiction, meaning it's the first and only court to hear the case, in a very limited set of cases, notably those involving ambassadors and other public ministers, disputes between 2 or more states, and certain other parties in which a state is a party. Otherwise, the Supreme Court exercises appellate jurisdiction, hearing most cases on appeal from lower courts. As such, the Supreme Court serves as the final arbiter of the federal constitution and statutory issues, ensuring a uniform interpretation of national law. In addition to the general federal court system, comprising the district courts, the courts of appeals, and the U.S. Supreme Court, the United States has a variety of specialized federal courts and administrative courts designed to handle specific cases or specific areas of law. In general, these specialized courts allow for expert adjudication in complex or highly technical areas of law and policy, and serve to reduce the workload on the rest of the federal court system. The U.S. Tax Court handles cases involving disputes over federal income taxes and between the IRS, the Internal Revenue Service, and taxpayers, providing a judicial forum for resolving tax disputes before the payment of assessed taxes. The United States Court of Federal Claims hears claims for monetary damages against the U.S. government, including claims related to contracts, takings, federal employment disputes, or vaccine injury compensation. The United States Court of International Trade handles cases involving international trade and customs laws, including the classification and valuation of imported merchandise, customs duties, and unfair import practices. And while technically part of the Courts of Appeals, the U.S. Courts of Appeals for the Federal Circuit has nationwide jurisdiction in specialized areas, including patent law, international trade, government contracts, federal claims, veterans benefits, and public safety officers' benefits claims. And many federal agencies have administrative courts, also known as tribunals or boards, which operate as quasi-judicial bodies within their respective agencies, handling disputes, enforcement of regulations, and administrative matters related to the agency's function. Some of these include the Board of Veterans' Appeals, which reviews and decides appeals on veterans' benefits such as disability compensation, pension, education, and more. It's part of the Department of Veterans Affairs. The Social Security Administration's Office of Hearing Operations conducts hearings and issues decisions involving claims for Social Security benefits, including disability, retirement, and survivors' benefits. The Executive Office for Immigration Review, often referred to informally as the Immigration Courts, handles cases regarding the legal status of individuals in the United States, including deportation, asylum, and other immigration-related matters. Although technically part of the district courts, the federal bankruptcy courts specialize in handling bankruptcy cases under the U.S. Bankruptcy Code. And each branch of the U.S. military maintains its own military court to handle courts-martial and military commissions for handling cases of military law and justice involving service members. For the most part, the decisions of the various administrative and specialized courts in the United States can be appealed to the U.S. Courts of Appeals. An estimated 40 million cases are filed across the United States in an average year, approximately 1 for every 8 people in the country. Of those, roughly 90% are filed in state courts and 10% are filed in federal courts. And of these cases filed in federal courts, more than 90% are heard and resolved at the federal district court level. Each year, less than 10% of the cases are appealed to the U.S. Courts of Appeals. And of those appealed to the Courts of Appeals, an even smaller percentage are reviewed by the Supreme Court. Indeed, while the U.S. Supreme Court may receive 7,000 or 8,000 requests to review a case each year, it generally grants hearings to fewer than 100. But that's it for now. Please leave any questions you have in the comments section below, and thanks for watching. The court has discretionary appellate jurisdiction over cases from federal appeals courts and state supreme courts involving substantial federal questions, meaning that the Supreme Court can choose which cases it wants to hear.